Question 371. A real property seller can recover damages from a real estate broker if the broker A. acts in excess of his authority conveyed by the seller, b. makes a representation to the buyer authorized by the seller, c. discloses a material fact to the buyer regarding the intended use of the property, d. provides revised escrow instructions to the property's escrow agent. Correct answer is A. acts in excess of his authority conveyed by the seller. A real estate broker acts as an agent for the seller, and their authority to act on the seller's behalf is defined by the listing agreement and any specific instructions provided. If a broker oversteps these boundaries and takes actions that were not authorized by the seller, and these unauthorized actions result in financial harm to the seller has grounds to seek recovery of damages from the broker. This could occur, for instance, if a broker disregards a seller's minimum acceptable price and enters into an agreement to sell the property for a lower amount without the seller's explicit consent. In such a scenario, the broker's actions exceed their authorized power and directly cause a financial loss to the seller, making the broker liable for those damages. Conversely, a seller would generally not have grounds to recover damages from a broker for actions taken within the scope of their authorized duties and legal obligations. For example, if a broker makes representations to a buyer that were specifically approved by the seller cannot later claim damages based on those statements, assuming the information provided was accurate. Similarly, a broker's duty to disclose material facts about the property to potential buyers is a fundamental aspect of real estate law and ethics. Disclosing information relevant to the intended use or condition of the property, even if it might influence the buyer's decision, is a protective measure for all parties involved and does not typically constitute grounds for a seller to sue their broker. Furthermore, a broker's involvement in the escrow process, including providing revised instructions to the escrow agent as the transaction progresses, is a standard and often necessary part of facilitating a real estate sale. As long as these instructions are made with the seller's knowledge or consent, or are reasonably necessary to complete the transaction according to the agreed-upon terms, they would not typically lead to liability for the broker. The key factor in determining a broker's liability for damages is whether their actions exceeded the authority granted by the seller and directly caused financial harm.